So under normal circumstances, you will be able to take your benefits from the scheme when you reach the scheme retirement age. And as we've seen, those benefits will be dependent on three factors: your pensionable service, the accrual rate, and your pensionable remuneration. And you can see here how we work this out. So we simply take the number of years service, divide that by the accrual rate, and we times that by the pensionable remuneration that applies. Once your benefits are drawn, some of them will legally need to escalate, i.e. increase in payment, and they will increase by statutory minimum rates, which are announced each year. What escalation means is that effectively your pension has an element of protection from inflation in the future years, and the rate that it escalates at will depend on whether the scheme was contracted in or contracted out from the additional top-up pensions that we mentioned in learning outcome number 2. So we remember that contracting in or out actually ceased on the 6th of April 2016 when we went into the new pension freedom rules, but schemes that were contracted in, essentially you still got access to the top-up pension schemes alongside your standard state pension. So the graduated pension was the first one that was introduced. It ran from 61 to 75. SERPs, which ran from 78 to 2002, and S2P, which ran from 2002 to 2016. Most DB schemes, though, were contracted out, which essentially meant that you were removed from those top-up pension schemes. And the reason why most defined benefit schemes contracted you out was it had a positive impact for the national insurance contributions that the firm would pay, because technically speaking, you got a reduction in your NICs to reflect the fact that you and these individuals in particular would not be taking money out of the state purse when they retired through the graduated scheme, the SERPs or the S2P. Schemes, though, had to provide a minimum level of benefits to replace these. So whilst there was benefits from NICs, there was still an obligation placed on firms to make sure that that at least matched the actual benefits that were being forsaken by contracting out. And this was give birth to the guaranteed minimum pension, which we're going to look at on the next slide. So there's no real need to understand this in any great detail for this particular exam. However, I think it's broadly needs to be understood for the Big Bad World and for any advanced papers that you may sit. So the guaranteed minimum pension is all to do with contracted out defined benefit members, specifically those that were contracted out between the 6th of April 1978 and the 5th of April 1997. There was a GMP replacement scheme that then ran from the 6th of April 1997 to the 5th of April 2006, which was essentially known as requisite benefits. So an element of this was applicable really right the way through to the end of contracting out on Pension Freedom Day. So essentially what this meant was that you had to be provided with the equivalent to what you'd forsaken with SERPs and more latterly with second state pension. Any members of contracted out DB schemes with service covering the period when SERPs and this S2P was in place are likely to have guaranteed minimum pension entitlement in their scheme, particularly those between 78 and 97, where the real guaranteed minimum pension period existed. It's important to note that guaranteed minimum pension funds have to escalate, but they escalate at different rates to the non-GMP, the normal benefits that somebody would see. So in payment, if you're in a contracted out defined benefit pension scheme over this period, you will receive your standard benefits, your non-GMP benefits, which will escalate at one rate, and you'll get this GMP, which will also escalate at another. So it would seem like you were getting a top up to your pension, just not from the government, but from your retirement fund itself. So let's take a closer look at these escalation rates then, shall we? Starting with a non-GMP escalation. So this is the escalation of your actual pension, your defined benefit pension. And there was no statutory increase for any period of service that ran before the 6th of April 1997. Then in 1997 there was a statutory increase introduced, which was CPI with a maximum of 5%. And that stayed in place essentially up until the 5th of April 2005. Any service post 6th of April 2005 will also grow by CPI, but the cap is lower at 2.5%, so maximum 2.5% on GMP. So you may, if you've had a number of years service within a defined benefit pension scheme, essentially have that service broken down in terms of how that escalates. Your GMP benefits, which was only applicable, as we've said, for contracted out DB schemes, there was no escalation up until 1988. From 1988 to 1997, when effectively GMP ceased to be replaced by those requisite benefits we talked about, the actual scheme is responsible for this escalating by CPI to a maximum of 3%. Broadly speaking, requisite benefits between 1997 and 2016, broadly, they follow the non-GMP rates. So we're now going to talk about pension increase exchange, which is something that's offered by many defined benefit pension schemes, but only really applicable to those that choose to escalate above the minimum levels of statutory increases. So we've just seen on the previous slide the statutory increases to pensions. Trustees have it within their gift to increase by more, and essentially some firms will. So some firms may escalate by a flat rate of say 5 or 6% a year. That's within their grasp. Pension increase exchange is essentially where a member can choose to have the escalation above that minimum amount, the statutory amount, forsaken, in return for a higher initial pension that they can use essentially when they're younger and more active. Now, there's lots of pros and cons to weigh up here. You cannot essentially exchange all of your escalation of a pension on a DB scheme. It must meet the statutory minimum amounts. But let's say you're entitled to GMP maximum 2.5 increase. Your firm decides through the pension that they'll do 5%. You can essentially forsake the 5% increases and reduce that down to the statutory 2.5 in return for a higher initial pension. So in other words, the idea being is that you're fitter, you're healthier when you're younger, take the benefits then rather than it escalating right the way through at a higher rate through to when perhaps you won't be able to use the money as effectively. So lots of pros and cons to weigh up as to whether this is for you, and it is not mandatory on schemes to offer this. It is just an option that they may choose to employ. Now we're going to look at the pension commencement lump sum at normal retirement. And it's important to understand that a defined benefit pension is able to provide a pension commencement lump sum at retirement. In fact, many schemes do. The rules of the scheme are going to determine how this is accrued, and that is the way that you work out how much your entitlement will be through the scheme rules. It cannot provide more than the standard 25% though, but most DB schemes are probably at a lower level than that if the truth be known. So on some schemes, typically 1/80th schemes, you build up the PCLS in addition to your income. In other words, you don't need to give up any income to buy a lump sum. PCLS is often calculated at 3/80ths of your pensional remuneration. And again, we're going to look at an example shortly where we bring this alive for you and give you an example of how this is actually worked out. In other schemes, often 60th schemes, you need to buy the PCLS by giving up some income entitlement, and the rate that you need to give income up to buy the PCLS is known as the commutation factor, and we should be exploring this on the next slide. So here we have a situation of the PCLS shown here. We've already mentioned that you get on most 1/80th schemes, you qualify for the PCLS separately at 3/80ths of your final remuneration. And we're going to look at, as we say, an example of that shortly. Most 60th schemes operate on a commutation basis, and that basically means that you are going to need to give up some of your income essentially to buy yourself the lump sum. And we have a calculation here that is not on your tax tables that you are going to need to learn. The details of this though are that once you've essentially learnt it, the numbers are broadly the same in terms of what the calculation is. So we have pre-commuted pension, the amount of income you're entitled to, times by the commutation factor, divided by, and in brackets we have open bracket 1 plus open bracket 0.15 times by the commutation factor, close. So ultimately that at the bottom, that 1 plus the 0.15 times by C never changes. The only things that will change in this calculation are C, the commutation factor, and the pre-commuted pension. Now you will need to be able to calculate this for your exam because calculations are quite commonly feature in the exams that you're going to be faced with. Let's look at this in a little bit more detail. So the commutation factor essentially is the amount of PCLS provided for each £1 of income that you give up. So a commutation factor of 14 to 1 means that £14 of PCLS is provided for every £1 that your income is reduced. So in essence, the greater the commutation factor, the more PCLS you receive for every £1 of income that you give up. You do need to remember the formula, which is shown on this particular slide as well. So the greater the commutation number, technically, the better the actual PCLS you'll get, and the less income you'll need to give up to actually get a specific lump sum. Let's look at an example. So Zara is retiring after 20 years service in her 60th final salary pension scheme. Her final salary was £45,000 per year. She's been offered the opportunity to commute part of her income for a PCLS. If the scheme has a 12 to 1 commutation factor, then A, how much PCLS can she obtain? B, how much income will she need to forsake? And C, what will the revised pension be if the maximum PCLS is taken? Why don't you take the opportunity to pause this at this moment in time and try and work these out, because we will show the answers on the next few slides. So ultimately you can check your understanding of how this particularly works. So the first question was, how much PCLS can she obtain essentially from this particular arrangement? So this is the where we use our calculation in the first instance. So how do we calculate the income? Well, you hopefully will have worked out by now the year's service divided by accrual rate multiplied by final salary. So 20 divided by 60 times by £45,000 means that the pre-commuted pension is an initial entitlement to income of £15,000. We need to do that first because that's going into the calculation, as you can see. So we do £15,000, our calculated initial income, multiplied by the commutation factor, which is 12. That number there will be divided into the 1 plus 0.15 multiplied by C, which is our commutation factor. So in other words, you'll always use the same number for C in all of the calculations that you do. So 12, if it's 12 to 1 as this, 14 if 14 to 1, you get the general idea. So that's 15,000 times by 12 is £180,000. 1 plus open bracket 0.15 times by 12 gives us a number of 2.8 at the bottom. Now you must remember when doing these maths, the basic law of mathematics, do your brackets first. So you need to do 0.15 times by 12, yeah, and then add that essentially to your 1. So 0.15 times by 12 essentially is 1.8 plus 1, 2.8. 180,000 divided by 2.8 is £64,285 of PCLS. Very well done if you actually got that PCLS entitlement correct. The second question essentially asked you how much income would need to be forsaken to provide you with the PCLS. So on the next slide we'll have a look at that. So here we have it, part B. How much income will she need to forsake? So we've calculated £64,285 of PCLS. By dividing that by the commutation factor, of 12 in this case, we get £5,357 per annum reduction to the scheme pension. So of that £15,000, which was the initial entitlement, she would need to give up £5,357 of income. So that in turn will answer question C. What will the revised pension be should the maximum PCLS be taken? 15,000 minus 5,357 is £9,643. So again, the question is what does the individual in question who's retiring need and want their pension to provide? £15,000 a year or £9,643 a year plus £64,285 tax-free. Of course, the £9,643 is going to be taxed as earned income. So as we've said already and alluded to in the first section of this module, you can take benefits essentially from age 55 by exercising an early retirement option. Most schemes will allow you to take this, but there's a very strong probability that you will have a reduction in benefits for each year essentially, or each month even, that you actually take the benefits earlier, and the majority of schemes will work on monthly rather than annual basis. So in this case we use an example where e.g. a 0.5% per month reduction in benefit, 0.5 times by 12, for every year under essentially the scheme retirement age that you take your pension, essentially you lose 6%. Of course that will be prorated, so you will do that on a monthly basis to be more accurate to the actual calculation for most people. Your PCLS can be reduced in the same way, so the entitlement to that is affected as well. And employers can elect to cover the shortfall if they wish. Depends on how generous they are, depends on whether or not there's a health issue. There's lots of parallels that might decide whether early retirement is appropriate. You do find this is one of the specific reasons why some people want to move their money and transfer their money out of defined benefit pension schemes, is to move it as a CETV into a personal pension, and thus to avoid this reduction in benefit, because you don't pay the reduction in benefits when you transfer, you only pay this when you actually draw the benefits out. So let's have a look at ill health early retirement, and this can result in the early payment of benefits potentially without any penalties being applied. So you can, in ill health reasons, leave the scheme before the age of 55 without benefit reductions, and in some cases you will be afforded added years as well to top up your pension, depending on whether or not the reasons for your ill health potentially was caused by your employer. Certainly, I know a situation where somebody that is close to me worked in the police force and had an incident which caused their retirement before the age of 55, and they've drawn their pension benefits before 55 and have had them paid up to the maximum benefits that's allowable. Serious ill health, generally termed as life expectancy less than a year, can also allow the commutation of the pension as a lump sum. This is at the discretion of the trustees, but generally speaking, that is within their gift, and that can be tax-free if you're under the age of 75, provided you're below the lifetime allowance, which is unusual to have benefits that can come out this way tax-free. Ill health, of course, not serious ill health, but normal ill health, can, in some cases, be recovered from, and there are permutations of that as well, but they're largely beyond what we worry about. Sadly, we also, of course, will have members that will die before they draw their benefits, and of course, always we will have a situation where there'll be a death of people once they've drawn their benefits. So death benefits will depend on a number of factors. Final salary defined benefit schemes are duty bound to provide benefits in the majority of circumstances, really, but who they pay them to is at the discretion of the trustees. Members will be encouraged to elect to complete a nomination form as to whom they want those benefits to be paid for, but largely speaking, a particular death benefit before drawing of benefits is easier to pass on to other people than direct dependents. If it's benefits in terms of in retirement, it tends to be that you can only get these paid to certain categories of beneficiary. The trustees will always consider a nomination form that's been produced. They are not duty bound, though, to actually act on its behalf. And we're going to expand on that a little bit on the next slide. So on death, we can largely define the death benefits into two particular chunks. We've got lump sum benefits. This is essentially an option payable to from a final salary pension. The scheme can pay a lump sum death benefit of an unlimited amount, which will be assessed against the lifetime allowance, with a 55% charge being levied if that's above that. Or alternatively, and much more commonly, they can provide a income for the rest of a spouse, civil partner or dependent's life, which typically will be a percentage of the benefits that a member was entitled to. These can offer a guarantee, but a guarantee is limited to 10 years, and we'll look at guarantees in a little bit more detail a bit later in this module, having explored them in learning outcome number 2. So if you die before drawing benefits, then quite often there will be a death in service benefit that will be paid to the survivors, and potentially an income paid as well, an entitlement to say 50% of what the member would have been eligible for. If you've already crystallised benefits and are in receipt of your income from your scheme pension, it is very unlikely for you to get a lump sum. In that case, you're probably just going to get a spouse's or dependent's pension, however which way it works. So in many respects then, we're going to summarise what happens at retirement in inverted commas, in normal circumstances, ill health, and in serious ill health situations. So in normal circumstances, from the age of 55, you can access the benefits, but you will need trustee permission, and if you go earlier than the scheme retirement age, you're likely to have penalties. Retiring due to ill health can be done before 55. Again, it's at an element of scheme discretion, and you're going to need to provide the evidence of your ill health through general practitioners' reports and all of those sorts of things. There might be specific scheme rules that apply to ill health. that essentially means that the benefits will cease should you recover from a temporary ailment. But largely, the scheme will decide whether or not to pay you ill health benefits out given the circumstances, and whether or not they will be the benefits simply accrued, or whether they make up the benefits to what you would be entitled to had you continued to work. Serious ill health, largely defined as life expectancy below a year. You're going to need that evidenced, of course, through various different medical reports prior to them paying out any amount on a serious ill health benefit. But generally speaking, if you have got life expectancy of less than a year, you can often commute the benefits that you have in the scheme essentially as a lump sum. Still going to be a benefit crystallisation event, so there will be a lifetime allowance test in those circumstances. So in order to avoid a lifetime allowance charge, you're going to need to have sufficient lifetime allowance available.